Ladies and gentlemen of the public, welcome. This is our regularly scheduled meeting of the Metropolitan Government's Short-Term Rental Appeals Board, taking place at the Sonny West Conference Center, 2nd Avenue South here in Nashville on Wednesday, April the 21st. Happy to have you here. And for those tuning in, this will be a monthly board meeting, presently scheduled to take place on the fourth Wednesday of every month. After some original negotiations for Thursdays, we're landing on Wednesdays. Sorry for any confusion that creates for anyone. Certainly, if any cases today involve folks who are not present for their cases, we're willing to try to work with them for a rescheduled hearing at the next date, given that there was some question about the hearing date. Although it was correctly publicly noticed this way, we didn't want anybody to be confused. Thankful to have everybody present for today's meeting. We'll note that we're, of course, governed by the Metropolitan Code's ordinances that regulate short-term rentals with this board. Those ordinances are codified in both Section 6 and Section 17 of the Metropolitan Code of Laws with regard to the appropriate definitions, regulations, and restrictions for short-term rental operation in Davidson County. In each of the cases today, staff will make a presentation with regard to the facts of the case. Then the appellants will have the opportunity to state their appeals to the board. If in fact there is a contested case with opponents present in the audience today, then opponents would have the opportunity to present their cases after the appellants. The appellants would then be given an opportunity for a brief rebuttal period as well. Afterwards, the public hearing will be closed by the board, and the board will deliberate on each of the cases in an individual capacity. Afterwards, the board will take a vote. Obviously, 4 votes of our 7-member board are required for any motion to pass. Although we don't have a full contingent of 7 board members today, we do have 5, which is more than enough for the 4-member quorum required for any of their votes to pass. One piece of administrative business before we launch into the first of 5 cases for the day. The board needs to elect a vice chairman. As I have notified each of the individual board members before today's meeting, those who are present at least, our fellow board member Terrence Bond is in fact willing to participate. I know there have been some question in the role of vice chairman. And so, Madam Chair, I would solicit a motion maybe toward that effect at this time. And Madam Chair, if you would take the formal vote on that.
Okay, formal vote. All those in favor of Terrence Bond serving as vice chair to this body, say aye. 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 Okay, ayes have it.
And in the tradition of all good church work, the person who's not there has been so appointed. With that, we note that the chair will need to depart early today, and as a result, we have asked and been so fortunate that Ms. Kimmerling has agreed to chair the hearings as needed today. We thank you for that very much, Ms. Kimmerling. So if you'll give us just one moment, I'll take my seat again, and Mr. McBroom will come forward, and we'll prepare for our first case of the day. Like what I'm always does, and then turn it to you.
Okay, no mic today, and Councilmember Sean Parker.
I'm present.
Very good, thank you. Okay, let's call our first case and get the details from the representative on case SDR 2021-001.
And Madam Chair, as you know, that's a case involving the appellant Keith Icard and the property located at 11 Music Square East, Units 205 and 305, respectively. The appellant seeks permission to apply for a permit earlier than the law presently allows based upon prior violations. The board, if Mr. Icard is present, please come forward and take a seat here at the front dais. We'll hear from staff first. After Mr. McBroom's presentation, we'll hear from the appellant. Quickly, is there anyone here who is in opposition to case number 001? Seeing none, again, we'll hear from Mr. McBroom, then from the appellant.
Good afternoon, board. There was two type 3 not owner occupied multifamily permits on this case. 11 Music Square East, number 305 was issued on December the 11th of 2018, and number 205 was issued on December 20th of 2018. Both were renewed on 11/27/19. The permits subsequently expired on December 11th and December 20th of 2020, respectively. On February the 9th of 2021, both renewal affidavits were received by the Metro Codes Department after the 30-day grace period by 29 days and 20 days, respectively. The appeals were filed and the permit cancellation letters sent. The the appeal was filed on February the 18th and the cancellation letter on February 26th. On 11 Music Square East, number 205, the previous owner of the permit of the property also had an STR permit and ads resulting in numerous website ads to track by Metro's compliance contractor, which is Host Compliance. All of the ads were removed over time with the exception of with one exception, which was first posted on August the 18th of 2020 and remains posted as of 4/15/21. After the appellant was made aware that the permit had expired and could not be renewed, it was changed to a long-term rental ad, minimum of 30 nights. This makes it compliant with Metro's short-term rental ordinance as it's no longer governed by it. The calendar is blocked with no dates available until August 1st of this year, and then it requires a 31-night minimum stay. There were approximately 16 documented stays after the permit expired, and I state that it's approximate because the count is based on reviews on the website ad, which indicate the month in which the stay occurred and not the specific dates. The last stays were in February, of which there were 4. Again, the appeal was filed on February 18th of 2021. Although there have been several complaints about short-term rental properties in this building, there have been no documented complaints for Unit 205 in either the Metro Hub or Host Compliance Hotline. As for 11 Music Square East, number 305, there have been 2 websites identified for that unit. The listing on Airbnb, one listing on Airbnb was removed on 8/11/20, and the ad that remains posted as of 4/15/21 was first posted on August 14 of 20. As with Unit 205, when the appellant was made aware that the permit had expired and could not be renewed, it was changed to a long-term rental ad. The calendar is blocked with no dates available until January 1st of 2022, and then a 31-night minimum stay is required. There are approximately 15 documented stays after the permit's expiration, and the last stays were in February, of which there were 5. There have been no documented complaints for Unit 305 in either the Metro Hub or with the Host Compliance Hotline.
And Madam Chair, this would be an appropriate time if the board members have questions of a staff member. Otherwise, you can hold off on that and hear from the appellant.
Questions, anybody?
Yes. And I'd like to remind just for the viewing public at home, if we could all turn our red microphone button on when we speak. If staff could remind me, did you say that both of these listings were still up as of April 15th, 2021?
Yes, sir, that's correct, but they are listed as long-term rentals now,
Understood.
which is compliant
Understood.
with the ordinance governing short-term rentals.
Thank you.
And could I just clarify quickly, the permits that were first issued and then renewed, were they issued to the current owner or the previous owner?
The ones in question today were issued to the current owner.
Okay, very good, thank you. Any other questions? Okay, I am going to turn the meeting over to Ms. Kimmerling, and I'm going to ask to hear from the appellant.
Thank you. You're welcome. The floor is yours, sir.
And apologies, Mr. Reichert, if you would identify yourself by name and address for any speaker before the board, just name and address. Sorry, I forgot to say that earlier. Apologies.
Okay, thank you very much. My name is Keith Reichert. I'm the owner of Units 205 and 305 at 11 Music Square East. And, I printed out a packet just in case there, if any questions come up that might help with that. I'll hand them out. Here? All right. Now you can hear me. All right. Basically, what happened with our units is I made a mistake. I don't live in Nashville, Tennessee. I'm a Nashville native. I'm a proud Nashville native, and that's why I'm happy to rent my Airbnbs here. I currently live in Austin, Texas. When I purchased these units, I lived in Hermosa Beach, California. During COVID, my previous manager, I didn't feel was performing very well. As we all know, businesses were having troubles during those trying times. And so I canceled my relationship with them. And they were very appealing to me when I first bought my units in 2018 because I needed people to help me set up my permitting and stuff since I don't live in Nashville. They also did the previous renewals every year, in 2019. And I honestly, when I switched from having a manager to my local contact, I didn't realize that there was a permit renewal process. And so when the renewal came around, I just didn't even know it was a thing. And then I'd say between 15 and 20 days after the extended 30-day time period from when the renewal was supposed to occur, it came to my notice that there was supposed to be a renewal. That was on February 8th. I recognized that the permit was supposed to be renewed. And the very next day, I sent my colleague and friend Bridget down to Code's office to write the permit renewal fee, knowing that it would probably flag me for being past the past due date. I had never seen any notice. I moved from Hermosa Beach to Texas during COVID, so it's possible that maybe a notice that had been sent out. I'm not sure if you see it on your records, but I never saw any notice or anything. But without any notice, knowing I'd be flagged, I went and paid my renewal fee, and then, subsequently, 2 or 3 days later, we were notified that we were in violation, and then we proceeded with the process of canceling all of our reservations and setting up everything for a 31-plus day or a 30-day plus renewal, a 30-day plus rental period. That's the basic timeline. I've got further details if needed.
This time, are there any questions from any of our board members?
Sure. What is the renewal wait period that you're subject to having operated without a permit, or with an expired permit, rather?
I was told that we were penalized a year. That it's a year penalty.
Okay. From the date of expiration?
I'm not sure if it's from the date of expiration. I think it's from the date of violation. I'm not sure. I've always thought in my head it was the date of violation.
Okay, thank you.
And Councilmember Parker, the answer is within the department, we've typically applied that from the date of last violating use, when we can pin that date as best we can, or at the very least, the date that they at least tried to come in and file an appeal to rectify the situation, rather than, I think a very strict reading of the law would potentially suggest that it's only from the date of the board's finding that there was such violation. So theoretically, that could be today, and a one-year wait would run from today. But the staff at the Metro Codes Department, which is to say the zoning administrator, which is to say I have chosen to apply that a little more generously to application dates when at all possible.
Understood. Thank you.
What are the dates of the 4 stays that occurred in February 2021?
Ma'am, unfortunately, we do not have specific dates as far as that is concerned. The dates are based upon the renewals, unless the appellant can give you more information. That's what I have.
Mr. Icker, do you have that information of the dates of the 4 stays in February?
I mean, I know that people stayed in February up until when we violated, or up until when we were told a violation. That was on February 11th. We were constructed by David Frabut, that we're in violation. On February 12th, we changed everything to 31 day plus rental, and we attempted to cancel all of our reservations on that day, on February 12th. I have documentation that we were having trouble with Airbnb making that work. We have emails back and forth between us and Airbnb that we tried to do that. There's a lot of back and forth on the 12th and the 13th. And then finally, on the 15th, that was changed. So there was someone came in, I believe, right around that date, around the 12th. That's the only one stay I know that came after the cancellation, something that it was all a matter of timing. And, what we did was, when we found out we were in violation, we went and paid our renewal fee, and then we immediately went straight towards compliance and did everything we could immediately. And I think there may have been a 2 or 3 day lag as far as any rentals were concerned, but we didn't have anyone staying in the units after that, nor were we advertising it as short-term rental after that, meaning less than 30-day rental.
Are there any other questions from our board members today?
I have a question, just out of curiosity. Why is it says that you've blocked everything up until August 1 and then renting at 30 for a long-term rental, 31 days after that? Why the delay between now or February and August?
I'm not really sure I understand what the gentleman was discussing. As far as I know, and you can confirm this with me, we've been on 31 plus day rental since mid-February, and that's it. I don't know. Maybe we have some rentals up through that time period or something like that, but we are not blocking until August 31 and then have it on 31 plus day. We have it on 31 plus day rental indefinitely.
The website, the research on the website just indicates that the dates are unavailable, and therefore they may be booked for 31 night usage, or in some cases the appellant may choose to delay any bookings of any nature until after the board hearing. It's subject to the appellant's wishes, but it doesn't indicate as to the length of the stay, but it doesn't appear as though there's anything less than 30 days.
Thank you for that clarification. You have another question, Mr. Kabut?
Actually, I have 3 questions. First off, Mr. Eichert, how many other properties do you own that are
I own
Airbnb?
one other property.
One
I own
other
3
property besides these 2 listed here?
Correct. And with the renewal fee on that one, we paid all 3 on that same day. Okay. Yes.
Thank you. Would you mind sharing the documentation with the communication you had with Airbnb?
Absolutely. And I've got extra packets if y'all need them. Sure, here, let me. Thanks.
And for our board members, once you review any documentation that's been sent around today, please make sure and get that back to us on the staff level so that we can get it into the appropriate file for the case.
Before reading the conversation with Airbnb, I just want you to know that this packet just has the timeline, an extended timeline from when I purchased the unit, and the timeline, as best as I knew, as best as I know, in the front. And then most of the rest of the documentation is my permit renewals over the past couple of years, and my unit tax histories, just to make sure that y'all see that. In the very back, the last couple of pages is the communication concerning the glitch and reservation canceling. And on 212, you can see a response from Airbnb. Hi, Bridget. Thank you for reaching out to us about your concern. This is Mark, your support ambassador here with Airbnb. My apologies for the troubles. As I mentioned that your account for some reason is showing canceled. I will further help you out on your concern, and I'll reach back to you as soon as I've checked the problem on our side. I don't know what all that means, but so the communication had begun, and then you can just see a lot of back and forth, and Bridget reaching out several times, and even at one point saying, look, we're trying our best to not be in violation with the city of Nashville. If these reservations, on page 2 of the communication at 9:12 a.m., if these reservations are not removed, my chances of shortening our 1-year penalty for these 2 properties will be affected. I am operating with an expired license. This account issue must be corrected today. And so there was no response, and then it was resolved on that was a Saturday, and then it was resolved on Monday the 15th. And so you can see we were doing the best that we could to clear everything off our calendar. For some reason, we're having trouble doing that. And then, 48 to 72 hours later, that issue was resolved. So we acted as quickly as we could to take the websites down.
Just so for clarity's sake, on the 15th or 16th is when Airbnb canceled.
On the
reservations?
On the 15th.
15th? Okay.
Correct. Yeah, and you can see in our timeline, it was the 11th, we were told, and then, I think that was probably later that day, and then on the 12th, we attempted to cancel everything, and then it wasn't canceled to the 15th, and, I think there might have been some overlap there. But I can say with all honesty that we did not do any short-term rentals after we were told we were in violation, unless there was like an overlap on that day.
Thank you.
Councilmember Parker.
Thank you. Does the platform provide any means to log permit information with your account?
I don't know the answer to that question. As far as have the permit.
You have to have a picture of the.
Yeah, we have to have a picture.
Thing. But you have to.
But there's no function whereby you would enter, say, the expiration date and the platform would remind you?
No, sir.
Not that we know of.
Okay. Thank you.
We know the permit renewal dates now, and we will know in the future. I want to reiterate that there was no attempt to operate without a permit. We made a mistake because when I fired my management company and I asked Bridget to help me, my conversation with Bridget was, I would like you to help me with booking and cleaning and operations. And I didn't know that there was a permit renewal. I was all the way out in California, and I just, did not see it. And so we just had that conversation. And then when we realized, we immediately took action to pay our fee, even though we knew we were late.
What's your understanding of where your notices for renewal and communications from Metro come at this point? What's your understanding of the address? Are they directed to you at your address in Austin? To whom are they addressed?
I don't know anything about if notices were sent out. They were probably sent to my California address. It wasn't it wasn't one of the addresses that I thought of changing when I moved. I I don't know if a notice was sent out or not. I don't know if a notice of violation, I don't know if you see it in your records or not, but, you know, of course, if I'd received one, I would have immediately acted on that. But acting without knowledge of a notice, we went ahead and went in and paid our renewal fee.
Mr. Capucci?
Question for staff. Was there an actual notice sent? And do we have a date as to when that was sent and where?
What was
Do
your
you have
question?
a record of when when this notice was sent?
I'm actually in the process of trying to find that out right now.
Okay. And just also the address as to where it was sent?
Yes, sir.
Thank you.
This may be one where there was no notice sent because we didn't want to have it until they sent the renewal documents in after the expiration. In response to Mr. Capucci's question, as Mr. McBroom continues to look for the document, it's entirely probable that no notice of violation was sent, because it looks like from the timeline that staff prepared, it was the attempted renewal of the permit in February that notified everybody that there had in fact been the expiration. And so it was only with that we then took subsequent action to notify them of the issue and instruct them on how they could proceed if they needed. Mr. McBroom may find something different, but that's what it looks like from the timeline.
It would have been sent to the Hermosa Beach, California address, but I'm trying to find that.
I don't think there was. Or is it cancel?
Apparently, there was not one sent. This is a cancellation letter.
Just a cancellation letter?
Yes.
Can you say when that cancellation letter was sent out?
Yes, sir. February 26, 2021.
Okay, so is a cancellation letter means
With
a letter
apologies for what
notifying
may seem
us-
impolite, it's actually inappropriate to
Oh,
address
I
staff, but just
apologize.
address the board if you would.
Yes, sir.
Yeah, I hope that didn't seem rude.
I apologize. I'm just, so a cancellation letter, Mr. Carbucci, means that we're notified that we've been canceled after they, okay. All right, and I apologize for breaking protocol. Okay.
Any other questions from our board members?
I have just one clarifying question. Is there any legal requirement that notices be sent out of a permit's impending expiration, or is that a courtesy?
That is absolutely a courtesy. The statute, or rather the ordinance, has never had a requirement for the notices that we send. Frankly, we would love to be thought of as being courteous in sending those notices, but the reality is we're just trying to prevent the headaches that go with people not having a notice that goes out. And so sometimes folks don't get the reminder, hey, you're coming up in the next 90 days, 60 days, whatever. I think it's 60 days. Because they've changed addresses, which is not an uncommon thing, or mail doesn't get there. We don't know what happens to pieces of mail once we drop them in a mailbox. But fortunately for our staff, that's never been a requirement. We just send them out to avoid the big, huge piles of appeals that definitely would come from the point at which we choose to no longer send them.
Thank you.
The expiration date's printed on the permit itself, though, correct?
That's correct, Ms. Kimmerling. They are 365-day permits, stated as such on the face of the permits. It's a matter of setting a calendar reminder, same as your, I don't know, your driver's license tags or your dentist appointment or whatever else.
Anything further from our board members for our appellant? Is there anything else that you'd like to add for the board today?
No, I'd just like to reiterate, it was a mistake that my previous management company had taken care of these things for me, and I did not realize that I did not realize a permit renewal was a thing, and that we, upon, I want to reiterate that upon realizing that there was a renewal process, that we went ahead and immediately paid the fee the day after we found out, knowing that it would most likely flag us, as it did, that we were in violation, because we didn't want to operate, we wanted to be upfront about what had happened. So that's basically it. That's it. We made a mistake.
Thank you. Is there anyone else here present today that has come to address this particular item on our docket? This particular case. At this point, I'd like to close the public hearing so that our board can deliberate about case STR 2021-001. Then we will reconvene shortly.
And obviously, this is the point at which the board members can deliberate, talk about the case. If for any strange reason there's outstanding questions that staff can't answer, you do have the ability to reopen the public hearing for the very limited purposes of any specific question you need to address to the appellant. But this is your opportunity to size it up, discuss amongst yourselves, and arrive at a motion with regard to the appeal. Yeah, absolutely. Sean, throw something out there for us. Get a start on the chat.
Okay. Oh, sure. Well, I definitely appreciate the appellants coming through and providing so much information about the case. I'm glad that the opportunity's out there for, long-term rental of these units, certainly in the meantime of any wait period. I understand, that maybe the ask is to reduce the penalty, but I don't see much of a compelling reason beyond a mistake was made in this particular case, but I'd be happy to hear deliberation from other board members on that.
And just a reminder for any board members who want to participate in the deliberation, by all means, please turn on your microphone and speak into it during this period as well. Thank you for letting me make that little reminder.
I think I tend to agree with Councilman Parker here. My biggest concern, I think, is around the date of the firing of the management company. I think just as a business owner, if you have a management company or a manager that you terminate relationship with, it means that you have to take responsibility for their actions during the process, or as they're being rehired, or whoever you're rehiring. So I have a hard time coming to the understanding that we need to make any changes necessary to the 1-year wait period at this point, but I'm open to more discussion.
I am encouraged by the timeline that did occur in February, however. And I'm encouraged by the appellant's movement to switch the length of the stays and cancel pending reservations. And the fact that after the appellant was notified or filed the appeal in mid-February, that there were no stays after that. That, to me, is a mitigating factor that I would consider.
I do appreciate that.
Well, I tend to agree, and I think that, but I think also that if you're, having done this myself with another, with a company, management company, sometimes they do things and they manage things and you're not aware of when the deadlines are or anything. So I can give a little slack on this particular case. But I think the activity, once they found out, and made a move to stop everything as quickly as possible, I think that deserves a little slack.
Based on the board's comments, I'm going to make what I think is a motion that has a chance of passing today. We will see. But I would move that the appellants be eligible for applying for a new permit 9 months after the date of the infraction.
Is there a second?
Just ask a clarifying question. 9 months from which date are we talking?
I guess the infraction date would technically be the expiration date, since the ads are still up. Ads are considered an operation of a short-term rental business, and therefore the violation date, I think you used infraction date as your phrasing, would be the expiration date on the prior permit. Specifically, that appears to be 12/11 and 12/20 on the 2 units.
I'll second motion.
We'll take the vote. Councilmember Parker?
Aye.
Mr. Gobucci?
Aye.
Mr. Hogan?
Nay.
I'm going to vote nay as well.
The board can consider another motion. I would note here that pursuant to the Rules of Procedure, Part 8B, under case decisions, after discussion by the members and upon a motion, an appeal shall be granted or denied if that motion receives a majority vote of those members present at the meeting, meaning a 3-1 vote will carry a motion. I have advised the public incorrectly, I think, in my introductory comments that all 4 votes were necessary. That's actually a Board of Zoning Appeals guideline from the ordinance that governs their proceedings, not this entity. So, although that motion fails, the board can consider another motion if they wish, and a 3-1 vote will carry whatever motion the board eventually lands on.
I'd like to make a motion for the time period to be reduced to 6 months from the date of the permit lapsing. So, December 11th and December 12th.
Second.
Should we have discussion on the motion before we take the vote on the motion?
The only thing I would point out is that would essentially be, what is that, maybe 45 days from the present, which seems perhaps generous.
Okay. I'm going to withdraw my motion, and let's discuss what we think an appropriate time frame between the 6 and 9 months. What we think will be a viable motion that would pass.
Well, what do board members think about 6 months from today?
Apologize. Does that get us beyond what the 9 months would have been, though? I think that does, if we technically did.
I suppose it would.
perhaps 6 months from permit cancellation, which would be February 26th, 6 months from that date, which would put us at August.
If you will allow me to do a little bit of math, I did not go to law school for math, so I just need to put some pen to paper and look at a calendar so I can have an educated discussion. And if anyone wants to do that math, feel free to jump in.
It looks like 6 months from the date of the permit cancellation letters would put you in late August, which is the shortest or the earliest application availability date yet out of the motions that the board has kicked around.
Councilmember Parker and Mr. Capucci, what are your thoughts about an August date?
I'm fine with that.
Mr. Hogan?
I think that's reasonable, but I just would like to note that it is not, that in every case we'll be granting some degree of relief and that there are going to be cases where perhaps no relief is appropriate.
I would agree. I would make sure that there is a system in place if there is a change to a property management company, that there are backup calendars in place, that the board would maybe not be lenient for a second infraction, and would highly think that the board would not be lenient for a second infraction. And that I would ensure that notices and changes of address are properly filed for future communications. I think that my comment still stands. I do feel like it's a mitigating factor for the February transactions that occurred and the cancellation. So given that, I would make the motion that we do 6 months from the time of the permit cancellation, making the penalty period reduced to August 2021. We'll do an exact date on that.
Looks like it'll be August 26th.
Okay. Do I have a
Seconded.
second?
Second.
Take the vote. Mr. Parker, or Councilmember Parker?
Aye.
Mr. Capucci?
Aye.
Mr. Hogan?
Aye.
Aye as well. Motion carries. So
That concludes the matter. The motion has been granted. The appellants will have the opportunity to file their application for a new short-term rental permit for each of the properties, so permits, as early as August 26th, 2021. Obviously, you're not permitted to advertise or operate a short-term rental at those properties until those dates or until you actually have a permit in hand, not an application file, but a permit in hand. So please don't operate until then, so we don't have to see you again until then. But we look forward to seeing you then.
All right. Thank you very much for your time.
Thank you.
All right, board members, the next case to be presented to the board is case number 2021-002, involving the property at 1315 Wade Avenue. The appellant is the KG Family, LLC. The owners or operators of the property are the Nicholas and Sarah Campbell, represented by counsel today. We'll hear from staff first. After staff's presentation, we'll hear from counsel for the appellants. Mr. McBroom.
And I have to apologize that I did make a typo on this. It was not for an expired permit. It was for operating without a permit. On October the 5th of 2018, a Type 3 non-owner occupied permit was issued to the previous owner. On 10/3/19, it was renewed, and then 3 website advertisements were posted during this time, 2 of which were removed prior to the sale of the property. One on January 16th of 2019, and the other on July the 3rd of 2019. On June the 29th of 2020, the property was sold. The third ad, which has the previous owner's permit number remaining posted in it, 6/29/2020, and the third ad that has the remains posted, which has the previous owner's permit number. On December the 1st of 2020, Notice of violation was sent by Administrative Services Officer Campbell Paget from Codes for advertising and operating without a permit. On January 25th of 2021, the advertisement was changed to a 30-night minimum, or in other words, long-term rental, and it remains posted. On February 24th of 21, the appeal was filed, and there were no documented complaints on the property in either the Metro Hub or Host Compliance Hotline. I apologize, I left out that there were 2 documented stays under the appellant's ownership, and one was in September of 2020, the other was in November of 2020.
I apologize,
Staff's
Mr.
only footnote to Mr. McBroom's presentation is that we actually reviewed this case to determine what was the appropriate venue for the case to be brought. Having discussed that with counsel previously, we think it's appropriate to have it here before this board, although I think there is also maybe a related court case. Those are reviewing slightly different questions, one at the board, one at the court. That's not uncommon for short-term rental permit cases. Here, though, because it was an operation without a permit, it's not a question of expired and thus operation after expiration or cancellation based upon a change in ownership. It's a little bit different. And so if the board determines that staff made an error in terms of determining there was a change in ownership, thus ending the existence of the prior permit, if the board thinks that staff incorrectly read, interpreted, or applied the law with regard to the requirement for a new owner to get a permit, something like that is actionable, and the board could, in fact, grant some relief based upon the appeal that's been filed. That's why we think it's appropriate to have this here before the board. You won't see many cases styled quite this way, but those are kind of questions of law that are appropriate to bring here and let you consider, did staff err on those points? Having reviewed the brief submitted by counsel, obviously, I don't think our staff made an error in determining there was a change of ownership. That seems to be acknowledged in the brief submitted by counsel that there was a change of ownership on, I believe it was June 29 of 2020. I don't think that counsel's brief necessarily challenges the idea that a new operator does not get to care, or a new owner of the property does not get to merely continue on under the permit. That was just an honest mistake on the part of the operator in all likelihood. And so I'm not sure that those questions, I think those are kind of answered in counsel's brief to some extent. So I'm not sure that staff didn't think there was relief to be granted, but we did think it was appropriate to give them their day here before the board. I wanted to offer that. I know it's probably not a clarification, but at least that explanation of where we were coming from. And again, you won't see many of these cases, but we thought it was appropriate to come to the board. Sorry for the interruption at the end of Mr. McBroom's remarks. He may have had 1 or 2 other things there.
No further remarks unless you have questions.
Mr. McBroom, I apologize. I couldn't hear at the end of your presentation. You said that there were 2 stays under the current ownership?
Yes, that's correct. There was one stay in September of 2020 and the other in November of 2020.
Thank you. Any other questions from our board members for Mr. McBroom at this time? All right, then we'll move forward to hearing from the appellant, and will the representative please identify yourself by name and address?
Thank you. My name is Grover Collins with Collins Legal. Address is 414 Union Street, Suite 1110. That's Nashville, Tennessee, 37219. It's my pleasure to be in front of you, this board, this afternoon. Mr. Michael correctly pointed out most of the thrust of the appeal. We submitted an appeal in the paperwork, and you should have that in front of you. We attached some exhibits as well. Based on the conversations and questions of the previous hearing, the notice of violation is our Exhibit 1. That'll be toward the back. And then Exhibit 2 will be an email from Mr. Frobet that was communicated to me. That's basically his synopsis of where we're at. I think it's important for the board to understand that KG Family is the management company. Okay, they are not the owners of the property. They are the ones bringing this appeal because they were in charge of ensuring that the permit was in continuum and operational. So what happened was KG Family managed the property for the previous owners. They were under the mistaken assumption that the SDR permit that was acquired in 2018 would continue on to that new owner. In fact, they are the ones that alerted Metro that there had been a change in ownership, and that's what happened on around July 16th in an email to Mr. Frobit. Mr. Marr, the owner of KG Family Management, let Mr. Frobit know, hey, we've got a change in ownership. The reason that was happening was because they didn't realize that they, at that point, needed to apply for a new permit because they had this active permit. Roughly a week later, Mr. Frobit then communicates to Ms. Lifshey in the codes office that this permit needs to be canceled. The disconnect from my client's perspective is that they weren't alerted that there had been that cancellation. So they had stays documented in September and in November of 2020, but that's prior to them getting what's Exhibit 1 to the packet, the notice of violation. So to their mind's eye, they were operating correctly and then would have to appeal a new one. Now, that was an incorrect assumption, and I would let you know if they had called me, I would have let them know that, but they didn't do that. So it was one of those things where they were operating under an incorrect assumption that they had a valid permit. I can assure you that they wouldn't have had these documented if they thought it was a violation. And so that's why the disconnect is that communication. Now, to be fair to Metro, I don't believe there's any statutory requirement for them to notify someone because the law is the law. But at the same time, Mr. Marr was working under that assumption that because they alerted that there had been a property change, they would have been alerted if there was an issue as to the ownership. Now, they mistakenly, KG Family didn't make that application until they realized, hey, we need to make this application. They made that application for the new permit, but obviously it was after there had been documented stays, so now we're in this quandary of, well, you can't apply because you've got these stays, and we've got this case. So in this rare kind of occurrence, this is where we're asking for relief for them to go ahead and be able to apply for that permit, or in the alternative, at least backdate it back to the violation date. Obviously, it would be preferable if we could do it to the transfer date, but that's up to this board, and I'm happy to answer any questions that you may have.
Do you have any questions for Mr. Collins at this point from the board? Is there anyone else, well, first of all, Mr. Collins, do you have anything else that you'd like to add?
Not unless there is a question of the board. Actually, yes. I would like to point out, and I believe I failed to do this, there were no complaints or anything like that logged against this property. These people have been responsible owners or responsible managers, with the exception of not getting the new permit. But there haven't been any noise complaints or other documented complaints or things like that you would see in a STRP that's been out of compliance or otherwise a bad actor.
I do have a question. Are you here, you're here on behalf of the property management company, not the property owner?
Both.
Both. Okay,
Right.
Thank you.
If there are no further questions from the board at this time, are there any comments or anyone else who is in attendance with regard to case number STR 2021-002? At this time, we'll close the public hearing so that the board can deliberate regarding the case.
Don't make me go first again. Okay. This seems fairly cut and dry to me. I certainly understand why relief would be sought, but this is just a case of a person operating without a permit, and the penalty for that, I believe, should be. I don't believe that staff has erred here. I believe that the penalty should be what it is for everyone else, which is the year.
I actually think I have a question that I'd like to inquire. So I'm going to open the public hearing back up for that purpose. Then we can go back to our deliberation. So let's open the public hearing back up. Mr. Collins, your property management company, the KG Family Property Management Company that you're here for today, how many short-term rentals do they handle in Nashville?
That's a good question. I don't have that answer readily available to you, and I apologize for that. I can tell you it's several. I mean, it's more than one. I don't think it's more than 5. I could be wrong about that, but I mean, in candor with the court, I don't have that number. It's more than one. So.
And how long has KG Family LLC been operating as a property management company for short-term rental properties?
At least since 2018.
Okay. Any other questions from the board? All right, let's close the public hearing again, and we can deliberate, and then we can come up with a motion. I think it is compelling if they do handle several short-term rentals, particularly since 2018, that they should be aware of a change of ownership impact on permitting. Mr. Hogan, Mr. Cabucci, do you have any further insight?
Other than I agree, that's it.
Same here. But it's a shame that the owner is the one that suffers from it, not the management company.
I think we can all empathize with that, but unfortunately that is just a part of doing business in that regard. Do we have a motion from any of our board members or a proposed motion that you think we need to go back on the record and make?
Is it, if I may ask, is it necessary, what might an example motion be if the board's intent was to not grant any reduction in the wait period?
Motion to deny the appeal.
Okay. Well, I would move to deny the appeal.
Well, we'll need to go back into, do we have to go back into I guess no, we don't go back into public hearing.
If you have questions of the appellant,
then yes,
go back into public hearing.
Okay.
If you reclose the public hearing, go back into deliberation, then you can.
Yeah, we closed it. We're technically in deliberation, so then we can just make a motion from there. Okay. Councilmember Parker, I didn't mean to interrupt you. I want to make sure that we're following our procedural steps today.
Yes, I would move to deny the appeal.
Is there a second? Councilmember Parker has moved to deny the appeal. Is there a second?
Second.
All right, we'll put the motion to a vote. Councilmember Parker?
Aye.
Mr. Cabucci?
Aye.
Mr. Hogan? Aye. And I vote aye as well. Motion carries. The appeal is denied.
For members of the board, our next case is 2021-003 involving Sean Vance. The appellant and owner of the property at 222 Polk Avenue, unit number 401. The appellants are represented by counsel, Mr. Collins. We'll have a presentation from Mr. McBroom with regard to the case at that property, again, 222 Polk Avenue, 401. And then we'll hear from the appellants after the staff's presentation. Mr. McBroom.
On February 15th of 2018, a Type 3 not owner-occupied permit was issued. There were 2 website ads posted in February of 2018. On January 9th of 2019, the permit was renewed. On March 27th of 2019, a VRBO ad was removed. On February 15th of 20, the permit expired. On April 7th of 20, the renewal documents were received by the Department of Codes 22 days after the 30-day grace period had ended. On June 1st of 20, application for a new permit was filed. On 7/1 of 20, zoning review application canceled by the zoning examiner Robert Osborne due to advertising and operating with a permit pending. On January the 2nd, notice of violation was sent by the same zoning examiner, Robert Osborne, for advertising and operating without a permit. And the violation notice specified that the violation should be corrected prior to July 31st of 2020. On August 17th of 20, the property remained in violation and a warrant was requested, and the courts were then closed due to COVID-19. There were 2 documented stays in July of 2020, 3 documented stays in August of 2020. On September the 4th of 2020, the Airbnb advertisement was removed. There were no documented complaints against the property in either the Metro Hub or host compliance.
Are there any questions for Mr. McBroom from the board at this time? Hearing none, Mr. Collins, floor is yours.
Thank you. In case number STR 2021-003, my name is Grover Collins, Collins Legal, 414 Union Street, Suite 1110, Nashville, Tennessee, 37219. I'm here on behalf of Sean and Bryn Bailey Vance. This case is a little different than I would suspect any that you're going to hear. I've got a very long appeal packet, and I trust y'all have had a chance to go over that, but I will try to hit the high points for you as we go through this. This was a permit that was approved in 2017. That's CASR 2017-079381 that was approved on that February 14th of 2018. In 2020, they failed to renew it. And they didn't realize that they had failed to renew it in the midst of COVID and everything that's going on in February of last year. And they had 3 times where they rented it prior to being made aware of this in June 1st of 2020. That's when they became aware that they had failed to renew. So they went about applying for a new permit, and they had taken down their listings at this time. When they went about doing their new listings, going about getting the new permit, on July 14th of 2020, Ms. Dawn issued a check to Metro in the amount of $313 for the new STR permit of 2020-033-607. Metro deposited that check on July 24th of 2020, and on July 24th of 2020, Ms. Dawn inquired into the status of the permit, and this is where the exhibits will be pertinent to you as you look for that email from Cindy Story. And Metro employee Cindy Story indicated that she had spoken with Margot Potter. Again, Margot Potter is one of the Metro employees who's tasked with sending out the permits. And Cindy Story said, on behalf of Margot Potter, she has mailed out your permit for Polk Avenue. At which, based on the fact that the permit had been mailed out, they resumed rental of the property. And then on September 1st of 2020, Davidson County Sheriff's Department left a notice for a warrant that they had, come into environmental court because you're operating without a permit, and that would be an environmental court. So then when she got this warrant, they then inquired again to Ms. Story, and Ms. Story replied, I'm working on this. I've got to get a hold of our short-term rental department and have them look into it further since it's now canceled. We believe the permit was not issued, but payment was taken. So you are fine. We just need to get it issued again and have him return it to active to your permit to you. So sorry it's been a day, and I'll just let you know as soon as I hear back from them. So after that, Ms. Potter also replied to that email, again, Metro employee Ms. Potter, not sure why Metro was allowed to post the payment, but after contacting the short-term rental examiners, the permit was canceled, and here are the attached refund forms. So then that's when the appellant reached out to Mr. Osborne to understand what had happened, and that's when he was said that there was a decision made to cancel the short-term rental permit. The relief I'm asking for here is, I believe that there's simply was an error was made somewhere in the chain of Metro. I don't believe I can assign blame to any individual Metro employee. I just think when everybody's working from home, there was just probably a miscommunication on why this permit was posted, why the payment was posted, why it was communicated that the permit was being mailed. And I think it's reasonable for any citizen, upon receiving, hey, your permit is in the mail to you and we've cashed your check, that they should expect that permit to be valid. And I don't think it's reasonable for someone to then be held accountable or have an action against them based on the fact that this permit had already been sent out to them. In Exhibit 1, you've got several emails. The one from Cindy, that one starts the 3rd page and 4th page. You'll see the signature from Cindy Story, Metro Codes, Department of Building Safety. And then behind that one, you'll see the email from Mr. Osborne. I think it's important to keep in mind that had the Vance Luce contacted me when they failed to get their permit renewed in February, I don't think the course of action would have been for them to then apply for a new permit. I think the state law would have come into effect and they could have just simply gotten that permit back after getting what they required on permit fees and affidavits and that kind of thing. I think it could have been simply reinstated. However, I wasn't a part of that discussion, and they went ahead and reapplied, which adds some time and that kind of thing. However, even while they reapplied, before they started renting again, they waited more than a month before Metro said, yeah, you're good to go, we're mailing out your permit, and we've cashed your check. So that where I believe the error is the cancellation, especially after you've been told that it's valid. And so that's why we're requesting not a reduction in the time for them to apply, but simply just, yes, this was an error, we're reinstating your permit.
Any questions of Mr. Collins from the board at this time?
Mr. Collins, thank you. So I have a number of emails here. Can you point me, they're in chronological order on my end. Can you point me to the email where you believe the misleading communication or potentially misleading communication was made?
So if you start at Exhibit 1 and you go, not counting that one, you go one email that has Mr. Farabit at the top. The second page has Polk Avenue at the top. The third page has a Gmail thing at the top. Are you with me? And then that fourth page starts with, I spoke with Margot.
Who is the email from? Oh, I see it.
Members of the board, to assist Mr. Collins and you in your kind of explanation of the key players here, Ms. Story and Margot, or Ms. Potter, as referenced in these emails, are Metro Codes employees who work in the permit issuance side. They don't make any determinations over eligibility, legal requirements. It's a much more transactional nature of their job, at least largely. So they are helping people get payments made, permits processed, et cetera, just to help contextualize that, because I think it does add a little bit of appropriate color here.
And while I think that is certainly appropriate information as it relates to the circumstance of the case, I think it's also important to know that the average citizen doesn't know that distinction on who does permitting versus who makes determinations or anything. They just see Metro Codes as this one large body, and if one says, yeah, you're good to go, you're good to go.
Mr. Collins, so it says here, property continued to operate after expiration of the permit, which is, it seems that's not contested. And then with the application pending, are applicants not made aware of the need to wait for their permit to actually be issued before they can begin renting?
I don't believe that's clear, but just so we're understanding, or we're clear at least on what my clients have told me. In the past, Metro has sent out notices that, hey, your permit's about to expire. They are not required to do that. And as Mr. Michael was talking about earlier, they did that as a courtesy. They don't always send that out. So, but some people in the past have received that notice, and that triggered them to say, hey, we need to do something. When they didn't get it the next time, sometimes they're unaware that they needed to go ahead and renew that permit. So in this case, their permit expired in February of 2020. They then were later realized, hey, we haven't renewed our permit, and then immediately went to make application. During that gap period is when before they knew they had not renewed it and made that realization, and again, this is middle of 2020, right when everything's heating up, COVID-wise. During that time period, no, they weren't made aware. I mean, the law is the law, and people are responsible for knowledge of the law, but at the same time, no, there wasn't any actionable thing that said, hey, don't rent while you're applying for your permit. But regardless of that, once they made application and once they were made aware you're not in compliance, they didn't rent. So from the time they were on knowledge for the actual notice to them that we don't have a valid permit, they ceased operation, made application, and didn't resume operation until the email from the Story saying, we've mailed your permit to you.
So just to clarify, so you're saying that they became aware that they were not operating with an active permit, they went and applied for a permit. Through the course of that, they continued operating, and then when they got the letter of cancellation is when they began to cease operations. Is that the timeline here?
That is not my understanding.
Okay. Apologies.
My understanding is they became aware that they didn't have a valid permit and then ceased. And then made application.
I just, looking at the Tuesday, September 8, 2020 email from 8:34 a.m. from Mr. Osborne, property continued to operate and with the application pending. So I guess maybe if we can ask staff.
Yeah, and I don't mean to be coy with you or anything like that. That's just simply my understanding on.
Yes, sir. I know. I appreciate you being here.
Yes, the application for the, for the new permit was filed on June the 1st of 2020, and there are 2 documented stays in July and 3 documented stays in August.
But that would be after, and I don't have the date on the July, but the question becomes, was it after the email from Ms. Story in July saying, we've mailed your permit to you? And certainly that would be the case for the August.
However, there was a notice of violation sent on July the 1st.
But, and so that's also something that's kind of in the middle of this. You get a notice of violation on an old permit that you've already now applied for a new one. And then you've got a Metro employee telling you, we've mailed your permit to you. And I think that's, because if you look, and I attached, after the emails, you'll see the notice of violation. In those notice of violations, it doesn't cite your application number or your CASR number. It's the property and the map and parcel number. Okay? So if I get this notice of violation on June 1st, and I've already made application for a new permit, and then subsequent to that notice of violation, I have a Metro employee employee tell me after you've cashed my check that your permit is mailed to you and you're good to go, I think any reasonable citizen is going to say, okay, well, I can now rent my short-term rental.
Well, I mean, a previous applicant today did let us know that the platform does require a actual copy of the permit to be included. For me, I'd say I'd like to have that. If I'm going to go for a drive, I want that driver's license in my pocket, not in the mail.
Councilman, just for point of clarification, the requirement for the permit to be in the website advertisement is Metro's ordinance requirement. Platforms do not care one way or the other.
Okay, understood. But the sort of fact remains of, if I get pulled over, that officer's not going to want to hear, well, it's in the mail, he's going to want a copy of it.
Well, Councilman, respectfully, I don't think that analogy is the same, because a driver's license is much different than a business permit. And the council's clearly put this in Title VI as a business permit. It's not like you take your beer permit around the city, even though you've operated it. Now, it is hanging in the establishment. And like isn't the case here.
Was this permit hanging in the establishment?
Yeah, as is required by the Metro Code.
But if they did not have it at the time, how would it have been?
The permit that was given to them previously was hanging.
An expired permit?
They failed to renew it. As normally happens, when the new permit comes in, you simply slide it in front of the old one. It's the normal course. During COVID and all this, not many people are staying at these units. Not many people are going into these units. They realized the mistake that they hadn't renewed it. As soon as they realized that they had not renewed it, they made application for a new one. They didn't have any stays during that application period until they were told your permit is being mailed to you. Then they resumed. So if we want to make it the same as a driver's license, they weren't driving until they were told, yeah, we got your driver's license in the mail. Now, maybe they should have waited until the driver's license actually got to them, but it would have showed up in the system that they had a valid driver's license, which any officer would have been able to verify, which is what the governing body told them. We've got your permit in the mail and we've cashed your check. It wasn't until subsequently somebody said, no, we've canceled your permit.
Yeah. You can check permit statuses with the Open Data website.
I agree with
that. Would have been a very easy way to triple check on that, even if they weren't concerned about the requirement of having the permit hanging in the unit.
Councilman, I think what you need to, in my opinion, if we are saying to short-term rental owners and operators, don't just trust what a Metro employee tells you. You need to go ahead and independently verify yourself, even though a Metro employee has told you that your permit is on the way. If that's what you're asking people to do, then that's an entirely different course than what we've taught all these operators to understand.
I understand what you're getting at. I think that part of this is why we require permits to be on display in places. It's a verification that the process has actually gone all the way through, and not just that one person has confirmed that they've sent it to the next stage, or it might be subject to additional administrative review. I think this is why we put these fail-safes in, I think I've spoken a lot. So if any other colleagues have questions for the council, or
I think Mr. Kabuchi had a follow-up question.
So, thank you, Chair. One of the questions I did have, and this is more for staff, in terms of process, when a permit is applied or reapplied for or renewed, what is the typical wait period, or how long does that process take?
So you actually asked two questions that are going to have two different answers there. If it's a traditional renewal, Phil has a permit. Phil seeks to renew because it's going to expire in about a month or so. From the time you get that document to our staff, it's a prompt renewal. It's a matter of days. A check clears and you know that it's been renewed. There is no new sheet of paper that goes out in that scenario, i.e. a new permit. It's the same permit. The same permit number, and you got the same expiration date next year, theoretically, in that scenario. However, in this instance, a permit was expired, and therefore a new permit was applied for. There was one nugget in the timeline that kind of got talked past by all of us a little bit. When the permit expired in February, the prior operators or owners of the property, or operators of the short-term rental at least, did attempt to renew, but tardy in April. I think your timeline showed that as April 7. So 2/15, it expires. You have a 30-day grace period. 3/15, that runs. On 4/7, roughly 3 weeks after the 30-day grace period is run, there was an attempt to renew. So at least by that time, the folks were in fact aware that they needed to renew their permit. Doubtless, they found out pretty promptly. We would have seen that, seen the expiration date, and politely sent it back, hopefully with their check or whatever other method of attempted payment. And then, to their credit, they did come in on June the 1st to try to make that application. But that was after they had attempted and, of course, failed to renew in April, 6 to 7 weeks after they had expired. So for this, a new application, the turnaround time can vary based sometimes upon the fire marshal's review. And I know Mr. Collins has been through some of those situations with other clients in the past where maybe there are questions about whether or not the structure is arranged in such a way as meets fire marshal guidelines for hosting people. But typically, these are not long, slow permits. I think that generally an application, a week or so. They can run as long as 3 weeks sometimes because it's a matter of, although zoning's review is fairly prompt, do you meet the statutory or the ordinance requirements, yes or no? That's a pretty quick determination. But getting an inspection lined up for a fire marshal to come out and walk the space, give the approval, if there's any issues, rectify the issues, get the reinspection, sometimes it's a matter of weeks in that regard. So when you look at this timeline and see a 6-1 application, they were probably going to have that permit by the end of the month if everything went according to Hoyle. It didn't, of course. And so although I found myself interested in Mr. Collins' I think, reasonable discussion of the fact that it would be a lot to ask the average walking around Nashville to know, I've got this email from code staff. It says that I'm good. I know my check cleared. They said they're mailing it to me, but somehow that was ultimately not going to be enough. That would be perhaps a more apt assessment of a very cut and dry case. Phil walks in for his first permit. Phil goes through those processes. Here, however, there's an expiration. There's a notice of violation from Property Standards Division, separate from the application. There is a, based upon the prior application for the new one and the expiration of the prior one and the failed renewal on that prior one, ultimately, this is just not the cut and dry run-of-the-mill case. I think that was how it was introduced. In fact, you won't have another one like this, I think was what Mr. Collins, I really hope, correctly said. That said, it's a little unique. The timelines could be a little unique. Please forgive a winding answer to your question, Mr. Kabuchi. I really do try not to do that, believe it or not.
I appreciate it, you nonetheless. So then a follow-up question. I appreciate you pulling out the April 7th timeline note there. In a 30-day grace period, there's not a notification that's provided to the property owner that they've passed the 30 days. So like after, on 4/7, when they receive documentation, is it possible, does that get just sent back? Okay.
Yes, it's just simply, once we look at that documentation and confirm, oh, wait, they're expired, we'll send it back with a basic explanation. Here's your stuff, but you expired on this date. Your 30-day grace period ran on that date, and you're not eligible to renew. Your permit no longer exists.
Okay, so if the permit no longer exists and they were notified of that, sent back on the 7th or 8th, after the 7th, it's very possible that the appellants would have then received some kind of a letter in the mail saying that this was not approved or renewal was not made. And then they went ahead and still applied for a new permit.
And that would have been the appropriate next step if they wanted to operate again, was once they figured out that they no longer had a permit, you want to operate, you need to apply. So although they didn't do it in May, they might have been busy, they might have been unsure how to do it during the early days of COVID. We moved everything online. Not everybody got the memo, tweet, email, posting, website statement. You just can't, you try your best, but short of going door to door, some people, you're not going to reach with the message, and I totally get it. There were more important things going on for families than short-term rental permits in May of 2020. But didn't get that memo, didn't get in, made it in early June to get all their stuff in, presumably via email, and that started them on the path to righteousness.
Thank you. So I have a question for Mr. Collins. The owners here, Sean and Bryn, are they residents of Nashville? Or do they just own this property at Polk Avenue?
I don't know the answer to that question. I can look in my contact file and let you know that way.
And so just as a follow-up then, so the point of contact was Dawn, Dorinda Dawn, Ms. Dawn?
Mm-hmm.
And that person lives below, I'm assuming?
The address I have, I'm sorry to answer your first question. From what I have in my contact information is the Polk Avenue address. Now, that may just be the address that we had, but the contact information I have for them is here in Nashville. And then to answer your second question, I believe so, yes.
Thank you.
Mr. Collins, do your clients operate any other short-term rentals here in Nashville?
I'm not aware of that. And again, some of these questions, as we go through these, I'll anticipate the questions that you are going to have and have those. And it's certainly I can get that information for you if we, wanted to continue it or something like that. I almost suggested that in the last hearing. I don't have that answer for you readily available.
And so it's my understanding that there were 2 ads for this property, one VRBO and one Airbnb, correct? And then
That's my understanding from Metro.
okay, and the VRBO ad was removed, but the Airbnb ad still remained, correct?
I know that, I guess it would depend on the timeline that you're asking about. I think that they removed, when they made application for the new permit, they would have been required to remove all listings prior to making that application. Because one thing that Mr. Frobit is very good about is he'll check on Airbnb or VRBO when people are making applications to see if they have an active listing. And along with codes in that regard, I want to second what Mr. Michael said. Codes is very fast on these applications. It's just typically the fire marshal that takes the time to, because they're so busy with all the other buildings that they're approving, just for them to get out there and actually make the assessment. But to your question, as of the date of application, all of the listings would have had to be down or they couldn't have made the application. Mr. Frobit would have simply said, you can't apply because you have an active listing.
Now, I know you included as one of your exhibits a copy of the Airbnb listing, but unfortunately we can't see all the photographs that are part of that listing. Do you have copies of those photographs? And if so, what does the permit photograph look like with that listing?
I haven't inquired as to the permit, but typically, and again, I'm just speaking in generalities here, I don't know specifically, but quite often what I tell my clients to do is literally take a photo or a scan and then put that as one of the photos so that the permit is its own separate photo.
Right, but so I'm looking at this exhibit and it's dated 8/17/20, and I'm curious to know if they don't have a permit in hand at that point, but are required to have that photograph on the listing, what photograph of a permit did they have included on 8/17/2020 on Airbnb?
That's a solid question. I don't know. I can't answer that because I don't have I'd have to go back and ask them that specific question. I guess the question would then say, did they have the old permit or the new one if they didn't have it, right? I just don't have the answer to that question.
Were they aware that they needed to have a photo of the permit on the Airbnb list?
They'd been operating for quite a while, so Mr. Osborne and host compliance are very particular about these kind of things. They would have received a notification at some point throughout the course that you don't have it as part of your listings. But I would say this, and it's important for the board to understand as we roll through these short-term rental regulations. That would be a specifically applicable regulation as it relates to short-term rentals. So it wouldn't be a generally applicable regulation. So that it's something that in and of itself wouldn't be something that would keep them from having the ability to rent if they didn't have that on there. It would only then give them a potential for a fine until they came into compliance with that. It wouldn't strip away their right to use that property as a short-term rental. And that's underneath the Short-Term Rental Act that we've included in the pleading. So anything that's specific, and Mr. Michael, I'm sure will correct me if he disagrees with this sentiment, but if anything that's specifically applicable to short-term rentals in the regulation of them, which this permit being photographed would be one of those things. Not the permit itself, but the
photograph you're saying is regulatory, not operational.
Yes, ma'am.
Thank you for that clarification.
The way we've said that internally is it subjects you to a strike and a subsequent fine from a court if that strike is upheld, but it would not result in a cancellation of a permit.
Okay, thank you for that clarification. Any other questions from members of the board at this time? Hearing none, is there anyone else present today in reference to case STR 2021-003? Okay, Mr. Collins, do you have anything else you'd like to add before we close the public hearing?
As y'all go through these short-term rental regulations, I just want you to be cognizant of the fact that you are very quickly going to realize the difference between a bad operator and someone who made a mistake. These are operators that have been acting since 2018 when they got their permit, and they've done everything in compliance up until a mistake they made in 2020. When they realized the mistake, they tried to fix that mistake. You are going to have many people before this board that are flat out bad actors that just don't care about the code, don't care about what it says, and don't care about any of the consequences. That's not my clients in this case. They simply made a mistake. And when they made that mistake, they took down their listings and they tried to reapply. They were told, you've got a permit coming to you. They posted their permit back online. I think in this limited circumstance, it's one of those where the permit should simply be taken back to when Ms. Story said, yeah, you've got a permit, and just made active. I don't think there should be a waiting period. I don't think there should be any of those types, because by all accounts, except for this gap where they had an expired permit, and it's important to note too that even in that 30-day window, when you send in the money, it's suspected or thought by the owner that will just simply be done back into. Now, yes, they could have gone on to e-permits, and that's certainly something they could have done, and quite frankly should have done if that's what we're going to require of them. But in this case, you're not going to, especially during COVID times, if they sent something in the mail in April, they may not get that back until late April. They may not know that, hey, we didn't approve your permit until late April, early May, because everybody was working from home and Metro employees weren't coming into the office every day or even once a week for a while there. So I just think the timeline is hyper important in this specific case. I'm not asking this to be the case for all the cases that come before you. I think this is a very limited case in a very limited circumstance in a very limited time. And for that reason, I think this permit should simply be reinstated to active.
Thank you, Mr. Collins. I have a question, Mr. McBroom. I don't know if you're the appropriate person to answer it or if Mr. Collins has the information. I anticipate it's for you, Mr. McBroom, and that is between the permit expiration on February 15th, 2020, and this email dated July 24th, 2020, do we know if there were any stays during that time period?
Well, again, the permit expiration was February 15th. There were 5 documented stays in February, but again, we only know 5 documented stays in February. As to the specific dates, I do not have that. And then there were 3 documented stays in March. Also, the advertisements were removed and reposted between the 2 ads. A number of ads were removed and reposted 12 times between April the 13th and July the 16th. And then we had 3 documented stays in June of 2020. So 5 in February, 3 in March, 3 in June, 2 in July, 3 in August.
So between the time that the permit expired and the time that they believed they had a new permit in the end of July, Mr. Collins, there were at least, take February off the table because we don't know when those were in February, just giving your client the benefit of the doubt. You got 3 stays in March and 3 stays in June, knowing that they don't have a permit at that time.
I don't think it's a fair statement to say that we have documented stays. I think a documented stay from Metro is we saw a review, and Mr. McBroom can correct me if I'm wrong, but the only way Metro can say we had a stay is if there's a review and Metro's belief that the only time you can do a review is 14 days after. So if there was a review in that month, then they say that's a documented stay. It's not like they have a date, this is when that person stayed. And for this body, or quite frankly the court, and I've argued this before, to rely on that, I don't think is something that we can make as the deciding factor. I think you've got an email that went through. Let me get the exact date on that. You've got that email from July 24th saying that you're good to go and that they've got it. So and as far as the June stays, if there were June stays, and assuming that the way Metro does it is correct, you can also get a review when you've had somebody stay for 30 days or more. So there's no, the way in which we say we have documented stays for this, or at least the enforcement arm of this, is broken in my opinion. And I don't think it's something that can be imputed upon my clients that have made that application and then were given the go-ahead. And another thing that, and they're not here today, and that was, I keep my clients away when we're through this COVID thing because I'm here as a representative, but I have stated in Airbnb before and continually not left a review and continually gotten requests to make a review months after. So I don't know, and I can't definitively say that there were actually people staying in that unit in June. And I don't think Metro can either. They just have reviews that say, this is what we believe to be a documented stay.
Would it be a fair assessment, though, that your clients would have that documentation of who stayed in their Airbnb when?
Sure.
Well, Mr. Collins, I mean, I guess my follow-up question to that would be, would your clients be willing to, I don't know how that would be submitted or collected, but, is it possible for us to look through if they consent to that, to look through their platform history? If you're
For the
challenging
rental?
challenging the findings of the host compliance system.
Yeah, I don't see why that would be a problem at all. I mean, procedurally, I guess we could, I don't know the answer to that.
Yes, you can request it. Yes, they can provide it. No, they are not required to. There's no subpoena power here or anything quite so formal as that, but you can request it, defer an action on the case until our next board meeting, give it a specific deadline by which such documents would be submitted, say, for example, a week before the next meeting, should be adequate time, I would think. Yeah, you can request it, and if that's something you want to do.
I'm not quite to the point of that yet, but I just, if we're going to be sort of challenging the host compliance system and its ability to document stays, and it's possible that I think some of these extreme cases could trigger false, but it sounds like we have a number of them here, a number of documented incidents here. So the odds that, and like your example of 30-day stays, I mean, that volume of that number would not really fit on a timeline if those were all.
I think if you're counting, and I'm sorry, I didn't mean to interrupt.
Go ahead.
If you weren't finished, I apologize.
We have 3 in June, 2 in July, and 3 in August. So I don't see how those could all have been 30-plus day stays.
No, I understand that, but you have to understand that they've been told in July that they have a permit on the way. So anything after that, I think is irrelevant. If it's relevant to this argument, we can discuss that, but I don't see that as germane to what we're speaking on.
Okay, I think we've established that they did not have a permit at that time.
I'm sorry?
They did not have a permit at that time.
At which time?
The time you're referring to after the June, July, August period.
Well, they had been told they did.
They did not.
I'm not disagreeing with you that Metro had canceled the permit after they had told them that they had a permit on the way. I'm not disagreeing that that was the position of Metro. I'm arguing that they had been told you have a permit in the mail that was valid. So to them, I would disagree with the characterization that they didn't have a permit. I would think that.
Okay, I understand. I think we've spent a lot of time on that. I'll end my questions now. Thank you, sir.
Is there any further questions for Mr. Collins before we close the public hearing for deliberation? All right, let's close the public hearing so that we can deliberate. I will not make you start this time, Councilmember Parker. I will start, if that's all right. For me, in this, I am more concerned with the time period between the permit expiration in February 2020 and the presupposed permit in July 24th, 2020. I would like to have all the facts before us and would like to see what the stays, if there were actual stays, these February, March, and June stays in particular, I guess July too, since we've got the bulk of that month. I would like to personally see that documentation to have a full picture of this one. So I would love to hear from you guys, but I think you know sort of what the motion is that I'm going to propose.
I think that's reasonable. So, I guess that would be something of a continuance, push this to the next meeting, and then ask Mr. Collins to request that information of his clients. If they wish to put it forward, they're able to do so. If they choose not to, they are fully within their rights to do that.
Mr. Collins.
I'm happy to defer, and then we can continue that, and then I'll bring that. But the difference in the deferment would put it before everybody again, and they would have to review, but it would be the full vote. Am I incorrect in that, Mr. Michael?
The public hearing has been had. Once the public hearing part is closed and you're just in deliberation mode, if the board chooses to defer the case to another date, we can treat it as the board can reopen the public hearing if need be. Otherwise, it will be, as is the case with Board of Zoning Appeals, where the four of you who are participating today would be the voting members. Any board members who review the case file and the recording of this hearing in full will have the opportunity to confirm that they've done so and then participate at that later date. Although that is rarely the case, it is sometimes the case, but that is something that would be allowed. Otherwise, these four board members would be the voters at the next board meeting if the motion to defer with the request for more documentation is what the board moves and passes today.
And I would favor that, just due to the complexity of this case and the amount of time that the four of us have spent on it today. I believe that would be more prudent given the circumstances.
I agree. I make the motion that if Mr. Collins' clients so choose to provide us with documentation of their stays between the time period of February 15th, 2020 and July 24th, 2020. And our next meeting would be on May the 19th, correct?
Right there, 26th.
May
26th.
26th. If we could have that documentation from his clients by May the 19th, 1 week prior to the meeting. Is there a second?
Just a point of clarification. The date that you said that you'd want information through is what?
Is the date that they received this email from Metro presupposing that their permit was in the mail, so to speak.
But according to the timeline, and maybe I need to look at these dates again, but according to the timeline, the property remained in violation August 17th. Right?
Well, would the board like to or would we like to amend the motion to extend the time period for the stay information so that we have the full picture?
Yes.
Okay, so,
To amend through 8/31 at least,
okay,
and probably 9/4.
9/4 is when the Airbnb ad was removed. So the motion then would be documentation of stays between 2/15/2020 and 9/4/2020 to be produced on or before May 19th and defer consideration into the next meeting on the 26th.
I'd second that.
Let's take the vote. Councilmember Parker.
Aye.
Mr. Cabucci.
Aye.
Mr. Hogan.
Aye.
Aye as well. Motion carries. We'll see you at our next hearing, Mr. Collins.
Just a point of clarification, that motion is simply for us to produce that information and defer, correct?
Yes, we will take a vote.
No promise of action on either side once that is produced.
No, the scope.
There will be a vote taken at the next hearing regarding the outcome of the case.
Thank you.
I don't believe the scope of our consideration is limited in any way to the production of those
No.
documents.
It's not. It's as I understand it, Mr. Michael can correct me if I am incorrect, it will be a fulsome vote on the case as a whole for its disposition.
Thank you.
Thank you, Mr. Collins.
Board members, our next case is STR 2021-004 involving the property at 78 Evanston Avenue. Anthony and Sabina Sindek are the owners and appellants regarding that property. They seek permission to make their application for a short-term rental permit at a date earlier than the law presently allows based on their operation after a prior permit expiration. Mr. or Ms. Sindek, are you present today? If so, please come forward. And if not, Ms. Kimmerling, I would respectfully recommend taking a motion and vote for a deferral to our next board meeting, just in case there was any confusion over the notices of the meeting date. We can put this on the docket for the next meeting.
I move to defer case number STR 2021-004 to our next meeting on May 26th. Do I have a second?
Second.
I will take the vote. Councilmember Parker?
Aye.
Mr. Cabucci?
Aye.
Mr. Hogan? Aye. Aye as well. Motion carries. It'll be moved to the docket for the 26th.
The final case on today's agenda is case 2021-005. Kelvin Lowe, the appellant and owner of the property at 1503 21st Avenue North, seeks permission to make application for a short-term rental permit at a date earlier than the law allows. The appellant operated after the expiration of the short-term rental permit. As with all of our presentations, staff will make a presentation to the board. The appellant will have an opportunity to make his presentation thereafter. Is there anyone here in opposition to this case? Please signify by raising your hand. Is there anyone here in support of this case? If so, please signify by raising your hand. The appellant will have 5 minutes to make the desired presentation. I haven't made that announcement for everything, but we haven't bumped up against it, really. On contested cases, appellants have 10 minutes. I just wanted to double check since there were other people in the room. With that, we'll hear from Mr. McBroom on behalf of staff and then the appellant thereafter. Mr. McBroom.
On 8/23 of 18, a Type 1 owner-occupied permit was issued. 2 website advertisements were posted, one on 8/31 of 18, the second on 10/27 of 18. On August 26th of 2019, the permit was renewed. On March the 18th, one ad was removed. On August the 23rd of 2020, the permit expired. On January the 4th of 2021, the renewal documents were received. And on January the 8th of 2021, the documents reviewed by the zoning administrator, the permit was canceled and documents and payment were returned. On 12/31 of 20, the short-term rental appeal was filed. 30 documented stays since the permit expired, 14 documented stays since the short-term rental appeal was filed, including 4 this month. The ad is currently posted, and your notation says as of 4/19/21, but I checked again today, and it remains posted. The calendar has a minimum of 2 nights stay. There are no documented complaints for the property and in either the Metro Hub or with host compliance hotline. The calendar does appear to have future dates booked.
Any questions from the board for Metro at this point? Hearing none, if the appellant will please introduce himself, state his name and address. And
Hi, Robert Underwood, 1503 21st Avenue North, Nashville, 37208.
I'm sorry, what was your name?
Robert Underwood.
Okay, Mr. Underwood, please proceed.
This is a little bit different. I guess it's similar to what I've heard today, but this is just a case where the check was sent in. It was sent in, and I even have a copy of the document that it had to been notarized. And I don't know how many people I had talked to on the phone between myself and my assistant. I know that Debbie and I have talked, but the check apparently never got there. Now, I just figured, okay, it was COVID. We are the ones that actually discovered that, hey, the check didn't get cashed. In the documentation, it says that your check is your receipt. That is one thing that I had read. And so 2 months, I think it was in December, we noticed that the check, we were getting ready for accounting, and we noticed that the check wasn't cashed. And so we're the ones that notified Metro and said, hey, how come this check didn't get cashed? And then we were told that they never received it. It's first I'd heard of it. I didn't know this.
Can you provide us with the documentation for the check, or at least the date on the check, please, Mr. Underwood?
I've got the documentation along with the notary.
I think that would be helpful for us to understand the timeline in which you're speaking.
Which,
Yeah.
so that was notarized and sent in the mail on 8/1. The expiration was 8/23. So my argument all along was, look, I sent the check. I wouldn't just go hunt down a notary and send in a check, or not send in a check if I was going to take the time to visit the notary. And as I heard earlier, this is just a situation where, and I'm just assuming the way COVID has been and Metro employees, maybe it just got lost. I don't know. So like anything else, you would think that they would say, okay, well, look, send us another check, or we're gonna penalize you $100 or double the price or whatever it is. No problem. I have no problem writing that check. But at the end of the day, I feel like Metro also should have a payment system online. I think it's ridiculous that we're still sending checks out. I think it's silly. And I also think that this whole process with how many people we've had to talk to, because it started with us notifying Metro about why did the check not get canceled, or I mean, cashed, I should say. Started with Robert Osborne. Mr. Osborne then referred us to David Frabbit. David emailed us 2 forms to review and sign, and then he said to send in the documentation just like I'm showing you, which we did. We sent out the notices, but at this stage of the game, I was still confused. I was thinking, why are we doing this? It seems like a whole brand new application for a permit when I remember what kind of a nightmare it was at the beginning. So I just was confused. We're just talking about a payment, that's it. We're not in violation of anything at the time. There was no complaints. So the whole thing's just been very frustrating.
Councilmember Parker.
Eventually, I ended up talking to Debbie Livesey, and even though we had sent out the notifications and did what we were asked to do, she then had us do this again. And she sent out the notices herself. Then at that point, I was frustrated and said, I need to talk to somebody above you because this is ridiculous. I mean, all I'm trying to do is just write a check and pay this. So that's pretty much what my story is. Am I guilty of advertising? Yeah, I didn't realize that until I started hearing all this ahead of me. So this is my first go around at this. I only have one Airbnb, that's it. So I'm not an experienced multi-home owner that does this often. This is my first go around at this, so I apologize for any mistakes I've made. But again, I feel like I've done everything that I was supposed to do. So.
Mr. Underwood, what's your role with this?
So I'm one of the owners, and we did also send in information regarding that. I'm co-owner with Calvin Lowe. So this is an owner-occupied permit. I travel for business, so oftentimes I'm not there.
And did you tell me that you had documentation of the check that you submitted as well? Or
I don't have the check. I don't have no, I don't have the check. I don't know where the check is. It was sent in on 8/1, right, when that was notarized.
So,
and the previous year when it was renewal time, I actually went into Metro and dropped it off. And so that wasn't available to me because I wasn't able to get inside the building because of COVID. So
Mr. Underwood, you're stating that you, according to the documents that you provided, that you mailed this in August?
8/1.
8/1.
8/1, and the expiration was 8/23.
Okay, thank you. Question for staff. It says here that renewal documents were received on January 4th.
I'll welcome Mr. Underwood clarifying that, but it looks like probably a fresh batch of renewal documents were submitted on
Correct.
January the 4th in an attempt to move the matter forward.
Yeah.
Exactly what happened between, call it, end of August and January the 4th, I can't tell you. I know there was some back and forth. I don't know if there was 4 months worth. I have my doubts, but I don't have an email trail in front of me to confirm or deny that. But he made an attempt, it appears, on the 4th to make a new set of documents. And of course, we would have rejected those as having been very expired. I believe your timeline also shows that in that second week of January, namely the 8th, after my review of those documents, we denied the renewal at that time based upon the dates, of course. So the permit, of course, remained in canceled status or expired status, more technically, and returned those payments at that time.
Mr. Underwood, you first applied for a permit in August of 2018, correct?
Correct.
Okay, and you renewed that permit in August of 2019, correct? Did you get a new permit in the mail in August of 2019?
Yes.
You did? Okay, your permit expired in August of 2020. You thought you had renewed it in August of 2020 as well, correct?
Yes.
Okay.
Well, I mean, I sent the check in, but that's what alerted me was I looked at the permit that was on the wall and I said, where's the new one? Because I had somebody else checking mail and applying this when I'm not there. And I thought maybe, I don't know, if it was lost or what was going on. That's what alerted us to notify Metro and say, hey, did you forget to send us a permit? Do I have to go pick it up? What was the situation?
When was that?
I'm sorry?
When was that? When were you notified or
that would have
realized?
been-
I'm sorry, let's try not to speak over each other at the same time so that we can work through this a little more efficiently. When did you realize, hey, wait a minute, I think I've sent this stuff in on 8/1, I still don't have my hard copy permit yet? Where is it?
12/15.
I'm sorry?
12/15, and it wasn't because of the hard copy permit, it was because of the canceled check.
Okay.
There was no canceled check, or I'm sorry, there was no cashed check or record of the check being cashed at that time when we looked into it. And then I asked my person that does the cleanings, look at the permit and see if the new one is up or not. And then she said, no, it's not. And I said, okay, well, that's a problem. So we need to figure out, did they not cash a check because of delays in Metro because of COVID? What is going on? So there was never been any notifications whatsoever in the mail to me saying, hey, you're late, you're canceled, none of that, nothing.
Having received 2 hard copy permits previously in the mail in 2018 and 2019, you were expecting to receive another one in the mail in 2020, correct?
Correct.
You didn't realize it until you did end of the year accounting 4 months later?
I wasn't in the property then. I was traveling to my Seattle office, so I wasn't in the home. I had assumed that it was there. So when we were doing accounting and check, it wasn't like I physically looked at that particular permit. I just assumed it was up.
Ms. Kimmerling, if I can clarify one item on staff's behalf that I think will work to Mr. Underwood's benefit. I'm afraid he may have remembered something incorrectly from 2019. We don't send out a new permit with each renewal. I.e. a hard copy, a piece of paper that says, here's your new one. It's the same permit with the same permit number. That's been 2 years ago. There's no reason you should remember that in such detail.
Yeah.
We all get a million pieces of mail. So there wouldn't have been a new piece of mail that went out in 19. And even if this attempt at renewal had come to us, had been reviewed, had been approved, there would not have been a new piece of paper that went out in August of 2020 either. Again, it's the same permit with the same number. It's the same piece of paper. We just expect our folks, if they need a copy for some reason, it's something they can print through our website, through the not open data portal, one of our many clicks on our website that you can get to. But generally, we don't mail out anything new on that.
Understood. Thank
Hence
you.
the reference to the canceled check being your de facto receipt.
Okay, thank you for that point of clarification. I just have a few more questions, and I will pass the floor to my fellow board members here. Did you received a notice in December 2020 that says, you filed your appeal while you're appealing this, you don't need to advertise and operate the rental, correct? Okay, so you have heard Metro say that there are 14 documented stays since your appeal was filed, including 4 this month. What do you have to say about those stays? Are those stays confirmed stays? Or
Honestly, I literally up until 3/17, I was still trying to get some type of relief from this. By talking to Debbie, she can verify that I asked for her superior. And the thing is he didn't get back to me right away. And then when I told her that, I said, and then he did get back to me, and I said, this is what's going on. I think this is ridiculous. I just was trying to send a check in. You didn't get it. Why am I having to go through this whole process? And he said, and he confirmed at that time that we do have to go through this process. He can't do anything for me. So that being said, I have alerted my gal that takes care of the stays for me that we do need to take this down, and I apologize. I thought it was down. I honestly didn't even know, and I didn't realize. Never been through this before. Obviously, I was educated with everybody in front of me. I didn't realize the severity of this because again, I'm not a bad actor. I don't have any complaints. There's nothing, my neighbors are fine. So
Any other questions from other board members for Mr. Underwood?
Ms. Kimmerling, the final note from staff is just that the average, as noted in your presentation from staff earlier, that the ad was up and currently posted as of 4/19. I asked staff to check again this hour, and as of this hour, the ad is still up in violation of the short-term rental law.
if I had Wi-Fi connection, I would have done it right while I was waiting. Like I said, I apologize. That's the one thing I'm guilty of. But like I said, I just think from the beginning, again, 8/1, I send a check in. I have it notarized. I just don't have I didn't make a photocopy of the check, but I have the documents that were sent in. I saved those as a paper trail. So I don't know. I can't really explain anything else. I mean, it is what it is. I know it doesn't look good on your end because there's an ad up. It can be taken down right this second, but I just, was just hoping that John would have been able to say, oh, okay, yeah, this is a problem. Maybe some mail has gotten lost. We don't know. We see that you do have this documentation that you had it notarized on 8/1. That's fair. I mean, I'm thinking that Metro might be able to make some mistakes too during COVID time in collecting their mail. So it's not always the consumer that's at fault, I believe.
Are there any other questions for Mr. Underwood from the board? I believe Mr. Michael already confirmed that there is no one else present to comment on this particular case at this time. We'll move out of the public hearing and into deliberations. I guess I'll start. Are you going to start, Councilmember Parker?
I'm happy to begin. What sort of gives me pause here is just the number of documented stays. The number of documented stays since both permit expiration, a second renewal attempt, and an appeal being filed, as well as the fact that the listing is active as the appellant sits before us. I'm going to have a really hard time supporting any leniency, I think, in this case, and I think that they should be. In this case, I would even almost err more toward the appeal date, today's hearing date being the beginning of the 1 year, given the circumstances. But I'm not making that motion. I'll wait to hear other discussion.
Councilmember Parker was saying that he, and I'm paraphrasing, please don't let me put words in your mouth, that he is concerned with the lapse of time and the number of stays that have occurred since permit expiration and the appeal, and that he would not support any leniency, and that he would be inclined to run the 1 year date from today's hearing date, correct?
That is correct.
I would tend to agree with Councilmember Parker with point of clarification from Mr. Michael to ensure that we are correct on our interpretation of the 1 year time period as to when it can run. I agree that there are several documented stays. For me, the more egregious component of it comes from the notice that was received that specifically tells the operator not to operate and or advertise during the pendency of the appeal, and there were several documented stays after that time. So if we could get some clarification on the 1 year time period so that we can tee up a motion.
Yes, if you're seeking that clarification, the law states that the 1 year timeline runs from the date of the board's findings. So that would be today, 1 year from today. If the board wanted to do a lesser amount, it's probably wise to pin whatever number of days, weeks, months to today's finding date and just go forward from there. But the longest that could be is from today's date.
Having that information, Councilmember Parker, do you have a motion? Or does anyone else have any further discussion before we make the motion?
Sir.
Oh, wrong one. I have a question. John, Michael, when was the last day, the date of the last stay?
Staff records indicate that there were 4 stays this month. We don't have the specific date, of course, as we described earlier.
And I believe there was, and correct me if I'm wrong, there was a notation of future reservations pending.
Looking at the calendar, there are dates that are open and blocked within the same month, which would give that appearance. I can't say definitely.
Understood, Mr. McBreen. Thank you.
I support your motion.
Well, let me give it a shot, and then we'll see if we need any edits. So I would move that no relief be granted. The appellant is subject to the full 1-year waiting period beginning today's hearing date.
Second.
And that the appeal be denied.
And that the appeal be denied.
Second.
All right, let's take the vote. And we will, our chair has rejoined us, but will be, I presume, abstaining from the vote, for she was not here for the deliberations.
Exactly.
Councilmember Parker?
Aye.
Mr. Cabucci?
Aye.
Mr. Hogan?
Aye.
Aye for me as well. The motion carries. Mr. Underwood, 1 year from the date of today's hearing. And we
Members
have
of the
your
board.
documentation to.
Members of the board, that concludes all of the hearings for today. The next scheduled board meeting is May the 26th, 2021. We'll be in touch with you, of course, with the case packets in preparation for that meeting. With our chair and vice chair now elected, we should be able to handle those procedural nuances at our next date pretty smoothly. We thank Ms. Kimmerling very much for assisting us today in that role. That concludes all the business of the board.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.